Good evening, everyone, and welcome to the Policy Legal Contracts meeting this December the 1st. We'll get started here. Is there any questions or comments or corrections on the last meeting minutes? No corrections, no comments. Okay, any public participation? I don't see anybody for public participation. All right, well, I'll turn it over to our legal person to take care of this.
Thank you, Vice President Alexander. Tonight, we have some policies to review that were part of an October update from Neola. The policy updates from Neola came out in the latter half of October. We did not have a committee meeting in November, so we are going to bring this batch forward for your consideration, first reading tonight. They are transportation-related policies, and so you'll see a lot of them are revisions or updates. These are Department of Transportation updates, Federal Code of Federal Regulation updates as required by the Department of Transportation, and also related House Bill 96 language still being updated for the board's consideration. And Deborah Folk will be presenting on these policies tonight.
Great, thank you.
Good evening, Chairman Alexander, Ms. Autry, Pastor Harrison, Superintendent, and Legal Counsel. As Legal Counsel has advised, these are updates that came out of House Bill 96. There is also another related bill to this as well, House Bill 54. And these are policies that either have been in place and need updated, and we do have one new policy tonight. So our first one we are going to do is 4162, drug and alcohol testing of CDL license holders who perform safety-sensitive functions and are subject to DOT. These are your bus drivers, mechanics, as well as grounds crew, anybody holding a CDL within part of their particular job performance. So as you can see, highlighted in green are the updates. Anything that is sort of a pinkish red color and struck out are the changes that Neola provided to us that need to be deleted. These have been carefully reviewed, and the first one is a definition of alcohol, means the intoxicating agent in beverage, alcohol, ethyl alcohol, or other low molecular weight alcoholics, including methyl and isopropyl alcohol. On section F, we now have an addition that it now reads, the term CDL license holder means all regular and substitute bus drivers, other CDL licensed staff members who may drive students in board-owned vehicles or inspect, repair, or maintain your board-owned vehicles. Those are obviously your bus drivers, your substitute bus drivers, your mechanics, and as I said, your grounds department, warehousemen, other people that for the vehicle they drive are required to have a CDL. In G, they decided to put the actual term CDL license holder and struck out his or her. The next section is an update regarding exactly what occurs as far as controlled substances, and these are staff members who holds a CDL license and may operate a commercial motor vehicle. Those are your school buses, your dump trucks, other large vehicles that are considered under this classification, and they went ahead and then is tested for the presence of alcohol in the bus drivers or CDL license holders system. And we currently do have that in place for this group. And then it also added a new paragraph. A list of all active CDL holders are expected to be qualified to operate the commercial motor vehicle will be provided to the contracted certified testing center for purposes of managing the federally mandated random testing. And this list shall not include non-CDL holders. The federal mandated random testing program is under the federal statute, and we are currently in compliance with this particular statute. Now, the next set is items that we needed to select. The legal counsel, transportation, and HR has gone through this section, and it has been determined that option 2 is the one that the district would have in force. The drug tests are to be conducted in accordance with the federal and state regulations. A, prior to employment. B, for reasonable suspicion. C, upon return to duty after any alcohol or drug rehabilitation, which is part of the federal statute. D, post-accident. E, on random basis. And F, on a follow-up basis, and those are already what we are in compliance with. As you scroll down into the next section, these are just grammatical changes that they made in these areas. And so we now have an and or under section A that has been checked. The next sentence under B, they have gone ahead and struck out his or her safety sensitive function. And then the last set is the change at the last part of the paragraph. Nothing herein shall prevent the board from disciplining a staff member for misconduct associated with the staff members, not his or her anymore. It is the staff members' alcohol or drug use, regardless of whether the employee has disclosed having an alcohol or drug addiction. Yes, sir.
Question. What if a person comes and they have a problem and they come to the staff and say, I have a problem, I need some help? What would occur?
At this point, we would review those issues. We currently have through our HR department an assistance program. If they were tested to be positive, they would then have to be taken off the job while they go through the mandatory rehabilitation program.
Okay, so there is a program they can go to?
There is a program.
Okay,
and they cannot drive until they do the rehabilitation program that is certified by the Federal Department of Transportation.
Okay, thank you.
You're welcome.
I have a question. Yes.
Reverend Harrison.
Thank you, Brother Chair. I have a couple of questions as far as the policy. Now, I see the green is what we're updating. The strike-throughs is what is not, let's say option 1 was a strike-through, so we're choosing option 2.
Yes, sir.
So have we reviewed the policy for the sake of reviewing the policy, or are we just updating based on federal guidelines now?
We have done both. We have reviewed regarding the federal guidelines that we are to comply with for CDL holders, and we have actually reviewed each sentence and each item according to our previous policy as well.
Okay, and so I guess I would direct this to the superintendent. On these reviews, we seem to be having a disconnect with policy reviews. We had a process of reviewing policies in their entirety as far as the staff, the board, and I would ask that we would continue to review together. So we won't come to a first, second, and third reading and we get stopped. We have some dead policies on the agenda. I won't say dead policy. We have some policies on the agenda that we have not gotten to because we have not sat and went through the policies. So when we come to these policies, and I can understand the mandatory updates, but at a certain point we need to be reviewing policies to make sure that they fit the district in today's world and not just the Neola updates or the federal updates. And so I would just ask that. And I don't have an issue with this policy because I don't know enough to ask anything on this policy, but it's difficult to really ask pertinent questions when we come to a meeting and we're told that it's been vetted already. And I would ask that we would do that together. Through email, we don't have to wait for a committee. We can kind of, yeah. That was it. There's not enough time, so
Yeah.
we'll catch it on the second
I'm
reading.
glad you mentioned that too. Doing this sometimes brings up another point real quick, that we have to be careful when we're going through the policies, because we have the quorum, and you got to be careful with that open policy, and I'm sure it'll be discussed later on sometime, but we have 3 people who are on the committee, and we can't have all the board. So when you do that, we probably need to have the committee members do that along with maybe the staff, because if you don't, we'll have some problems, issues. So that'll be, I think that's something.
Yeah, that's fine. I mean,
Right.
we could do this, we don't have to meet as a committee all the time.
No.
We can do this through emails. Hey, we're going to do this policy, this policy, this policy, and it gives us a month to really look at this and kind of say, okay, well, these are our options.
Right.
And so everything, doesn't have to be done through the committee or on the committee day.
Correct, I agree with that. Okay, all right.
Thank
Ms. Hook,
you.
I'm sorry.
Under the staff member will be subject to disciplinary action up to and including termination for any of the following reasons. The update to this one is under Section A, reports to duty or performs work while having an alcohol concentration of any detectable amount or performs safety-sensitive functions within 4 hours of after using alcohol.
Pastor Harris?
So here's the law enforcement here coming out. So when we say any detectable amount, do we have a policy? Do we have a procedure? Do we have some kind of way of determining that there is a detectable amount, or are we talking, we smell alcohol? How have we been handling this?
First of all, CDL drivers must do a T8, which is a actual physical. And during that physical, in order to get their yearly certification to drive, they are drug tested at that time. They also do drug testing for what we call suspicion. If, to your point, if we would have one or more supervising adults suspect for a variety of reasons, we have the ability to drug test then. And then we always do post-accident drug testing when an accident happens with a school bus or a vehicle in which students are being transported. So we already have those in place. And then the other part of this particular policy is that these are also random pulls for CDL drivers. Currently, our transportation department gets that information. You are informed that you are on the list. We have an actual vendor that comes on site. They do those random drug testing, and they report those back to HR with obviously tests that are fine and tests that show an issue.
And I guess I was asked if Mr. C, I don't want to use a name, Mr. C shows up and someone thinks he's been drinking or she's been drinking,
The first thing you do is get a second adult to obviously observe the same things, and you immediately call HR. And that person, in our case, will not be put on the road while we are doing the reasonable suspicion investigation. And that is part of their collective bargaining agreement.
Is that good, Pastor Harrison? Or are you talking about maybe having
I'll
a
ask.
policy?
Yeah,
Okay.
I'll ask.
Okay, I think I know what you're saying. Do we have a current policy that talks about for any staff who has to get drug tested?
This is the one that covers transportation. The other one would be possibly in the HR venue, and I don't want to speak
Okay.
incorrectly to that policy.
Okay. Well, we can find out, because I thought Akron Public Schools has always had a policy, from far as I've known, that for any employee who is suspected of using some type of drugs, that they go through that policy, go through that process.
We do have a drug-free policy in general that covers a number of items.
Okay.
But these are transportation-related, and CDLs then go under the federal statute for DOT.
Okay, thank you. I think that's what you're, okay, I'm sorry, go ahead.
That's okay.
That's what you're saying.
Then we want to go down to Section E, and it fails to remain readily available for post-accident testing, which we just discussed. And the changes here are just the words notifying the staff members, not his or her supervisor or the staff member's location. It was just a grammatical update from Neola in order to make it correct to the statute. In the next paragraph, you will see his or her change to the staff member again. At the bottom of the page, a tested individual upon written request will be promptly provided copies of any records related to the tested individual's use of drugs or alcohol, including any records pertaining to the tested individual's drug or alcohol test. And then again, his or her is changed to the tested individual to refer to the person that's going through this process.
And Deborah, I didn't want to
Yes,
interrupt
sir.
for just one moment. I want to make sure I had the right number. But our current drug-free workplace policy numbers, 3122.01 and 4122.01. Sorry, Deb.
Thank you. And then this, under the next section, the superintendent shall submit for board approval a contract with a certified laboratory to provide the following services. We do have that in place, and a clear and consistent communication with the district's medical review officer or an MRO may be provided through the contract with the certified testing facility, and that is already in place. The update was may provide. And those notifications go directly to HR. Now we're under the educational materials related to certain federal regulations, board policies, and procedures. In this section, the update is the board designates the executive director of human resources or their designee as the individual that will be responsible for providing these educational materials. This is part of the actual hiring process. So that's why it is the executive director of human resources or their designee. And then the same update was done, the contact information for the executive director of human resources or their designee, who is the individual designated by the board to answer questions about the educational materials. As I said, this is part of the hiring process.
I'm sorry, just for clarification. So everything here, we're just talking about the bus drivers, the mechanics.
The grounds, anybody driving a vehicle with CDL.
Okay.
And that is a good question. Just hang on one second.
Okay.
And it is now changed, school board to be capitalized school board as opposed to small letters, school board property. Yes, sir.
Saying school board property, should it say school district property maybe? I guess every time I see school board, it makes me think of school board members. And so I think that's come up sometime earlier this year, and maybe it should read school district versus the board, because when it sounds like, I read it sounds like it's to the board. So I just wanted to bring that up. I saw that earlier, and I thought that would be a question I'd bring up.
Thank you.
Okay.
And the next is return to duty safety sensitive positions. This is the actual update that comes from the federal clearinghouse that is already in place, and this is the statute under which we now operate. Employees who are removed from performing safety sensitive functions as a result of this policy must complete the return to duty RDT process as required by the U.S. Department of Transportation, Department of DOT, regulations, and their Federal Motor Carrier Safety Act. Drug and alcohol clearinghouse status must be changed from prohibited to not prohibited before resuming safety-sensitive duties. So to your question, Pastor Harrison, this is why they cannot drive until this process is completed. The RDT process requires an evaluation by a qualified substitute abuse professional or an SAP, successful compliance with the SAP's prescribed educational or treatment program, and the follow-up evaluation by the SAP determining that the employee has complied with the program. The employee must then complete a DOT return to duty test and obtain a verified negative test result and/or alcohol test result of less than 0.02 before being permitted to return to performance of safety-sensitive functions. In addition, employees must comply with the SAP's written follow-up testing plan, which will be administered by the district in accordance with DOT regulations. An employee who fails to comply with the follow-up testing plan will not be permitted to perform the safety-sensitive duties. Subject to any collective bargaining agreement or other legal requirements, employees who are otherwise eligible to resume safety-sensitive functions may not do so without the superintendent's approval. The Federal Clearinghouse came out 2 years ago. We immediately put this into place, but this is the first time that this has been updated by Neola to meet these standards.
Thank you. Any other questions reference to this here policy?
I have one.
Reverend Harrison.
Thank you, Brother Chair. And I think this would be for legal counsel. The title of this, the 4162, Drug and Alcohol Testing for CDL license holders who perform safety-sensitive functions and are subject to DOT testing. Is it feasible to say all district CDL license holders?
It's possible. We can check and confirm on the statutory language. If there's a requirement, Neola usually puts that in the phrase,
Okay.
but I understand where your question is.
Okay.
Okay. Any other questions? All right. We'll
Okay,
continue.
so we're now going on to the next one. Okay. Okay, so. Alrighty, let's go here. So now we are showing, this is a brand-new policy. This is 4162.01. Drug and alcohol testing of employees without CDL licenses who transport students in alternative vehicles. This is non-DOT testing. I do want to give you a background as to why this has surfaced. Recently out of House Bill 96, we now can use smaller vehicles to transport students, and they have decided that they want those safety team members, as an example, our coaches, our CCAs, to also follow these same standards. So this is a brand new policy statewide. So this will involve non-CDL people. They do not necessarily follow the federal statute, but this is the new policy in the state of Ohio. So again, this is basically the same language that you see in 4162, but it talks about alternative transports. So I want you to think of units that transport 12 people or less. These could be vans, they could be small buses. And where this one gets a little complicated, it depends on the weight of the actual vehicle, which, although people say it's a 12-passenger vehicle, could require a CDL. It depends on the weight of the vehicle. So part of Akron Public Schools' plan is to keep ours at 9 passengers or less, which is what we have done for our van transports for years in the past. So again, this is the same language all the way through. It gives you all the definitions and terms for the type, and I want you to look at F. The term alternative vehicle includes all vehicles that are designated for 9 passengers or less that do not meet school bus construction standards. These vehicles do not meet federal definition for commercial motor vehicles and do not require a CDL operator's license. So that's why you now have 4162 and 4162.01. The language is exactly the same all the way through. In this case, the option was option 1. The drug tests are to be conducted similar to federal DOT regulations prior to employment, for reasonable suspicion, upon return to duty after any alcohol or drug rehabilitation, post-accident, and on a random basis, and on follow-up basis. So as an example, if I was a coach and I was certified to transport students, this is exactly what I would be using to follow for myself. Yes?
Does this have to be vans? Because you mentioned coach, and I know sometimes coaches may not have van, but they may have a car or a station wagon.
Actually, coaches can be certified to drive students. We always try to give them vans that we own, if at all possible, because those are the regulated ones that we inspect and we have on the road.
Okay.
And you do have a transportation policy that says students should be transported in board-owned or, certified vehicles as opposed to personal vehicles, unless they certainly are driving themselves, and that's another part of the statute.
Okay, that covers it.
Thank you. Again, the same two were selected under the end of the options. The test will be considered positive, and the employee will be retested. Under this section, the staff member will be subject to disciplinary action. Under A, reports for duty or performs work while having an alcohol concentration, and it was selected to be equal to the other, any detectable amount or greater, or provide student transportation within 4 hours after using alcohol. So it does meet the same standard as the other one. And then it does say that they shall submit for board approval a contract with a certified laboratory to provide the testing, which we do have in place. And then we also have the notification to the tested candidate, the reported results, and again, the educational materials for certain board policies and procedures will be provided by the Executive Director of Human Resources or their designee, because this is upon hire. On J, the consequences for employees found to have an alcohol consumption of, and we again selected equal to the other one, any detectable amount. Now, return to duty in this case, what was selected was where the X is, the employees are removed from student transportation functions as a result of this policy, must complete the following return to duty process, which is the same. And that is the end of that policy. So this is brand new, and we will be putting, if approved, we will be putting notification out to the staff members that would qualify for that. Currently, we have approximately 40 people that do these kinds of transports, taking students to internships, taking students to work plans, taking safety officers that transport students home in board-owned vehicles, and as well as coaches.
Okay. Any questions? Pastor Harrison?
Do we have training on these policies?
Yes,
how is the If approved, how do we?
Actually, for the ones that have been in place, part of this for the CDL drivers are part of their annual requirement of training of 4 or more hours per year. In this case, for this particular one, we will roll this out working with our safety team director, our particular CCA, and we will bring people in to go over these. Our next possible opportunity for training, if this is approved, would be January 16th or January 20th.
Probably won't be approved by then.
I have a question.
Yes, sir.
When do these have to be approved?
Actually, these are law at this time. It is hoped that we would bring these back to the meeting of December 8th for final approval.
Okay. So we'd have to probably waive third?
Yes, of the second reading to go to the third.
Okay.
This is 8600. This is our standard transportation update. This policy is just got some minor adjustments to them due to the fact that you can now see in the second paragraph the addition of or alternative vehicles, which we just explained are 9-passenger or less. Yes, sir.
You said that a couple times. How did we get to 9 or less?
When looking at the alternative, we've always had 9 or less to begin with, because that was all that we were allowed to have up until this recent change in House
Right.
Bill 96. And we know that, A, you cannot get the 12-passenger units right now, and second, we know the weight is going to, of the vehicle, depending on what is purchased, if they become available, could require a CDL, and we do not want to put that other burden on trying to transport by smaller unit. One of the reasons for the alternative vehicle becoming part of this as they moved through House Bill 96 was because of the lack of CDL bus drivers. So they were trying to come up with alternative ways to get students to school and to their events.
So can I ask you again?
Yes.
How did we come up with the 9? Because House Bill 96 says 12. So how did we come up with 9?
Can always make it different than House Bill, and
Right.
and that's why we felt we could already meet the 9-passenger standard.
And I guess that's what I'm asking for is I'm not asking you to justify it. I'm just asking for the process that we came up with.
Because that's currently what we own.
Okay.
Is 9 passengers, and our cars obviously are standard car, and our van supports are also 9-passenger or less.
Okay. And I asked that for the superintendent and general counsel because, of course, when we're looking at transportation, we're also looking at finance, and so. If that's what we have now, 9 is what we have, but for financial reasons, we may have to revisit that. But it doesn't matter now because we don't have anything but 9, so.
The strikeouts here were to be in the code K through 8 is currently living 2 more or miles for their address. That's been the state standard. They just gave you the option to go ahead and change it if you needed to, but the 9, the K through 8, 2 miles or more, we don't have all those different grade levels that you could put it out and make, kindergarten noon, because ours is all day. It just makes it an option for schools that are smaller than our district and our teams. Now, the specification here is transportation of eligible vocational or special education children between their home and area and schools. The as-related service is really related to students with IEPs, and those IEPs are written that transportation is a related service, and Neola updated that to that paragraph. Some students with IEPs do not get transportation as a related service. It's not part of the plan. And the next one was a strikeout on the sentence, transportation shall be provided each day the non-public school is open. The in which was not a grammatical issue they wanted to keep, because we are required to do each day the non-public school is open with students in attendance. In the last sentence of this paragraph, students transported to an approved community school may be assigned to ride on buses upon which resident students attending other schools are also assigned. And that has always been available. They just kind of rewrote the end of the sentence, and I'll give you an example. We currently have 2 schools here in Akron that are non-publics, and we pick up one first and pick up the kids together, and then we drop off at school A, go drop off at school B. In the afternoon, when they dismiss, we pick up at school B, go to school A, and then we take the students home. So this is just another way of rewriting the end of the sentence. Transportation of eligible non-public or community school children between their home areas and schools shall be arranged through the use of board-owned or contracted services. And so that was reflected, I think, correctly, board-owned, not school board. And then they also went and added through cooperation with other districts, through commercial carriers, or by means most efficient. The board will not provide or arrange for transportation of students enrolled in community or non-public chartered schools in any grades K through 8th grade using mass transit systems. You no longer can put a K through 8th grade student on a Metro bus. That is a huge change. Some districts, not Akron Public, have done this in the past, and this would not allow students to be always transported with us by Metro. Then there was some grammatical changes to the next paragraph. So obviously, as you read it, it's and schedules for eligible students within 60 days of receiving the start and end times. So this is when they have to notify us that they are expecting Akron Public Schools to provide their transport. And the deadline is April 1st.
And these are non-public schools?
These are community non-public schools. That is correct.
So, and we're required to transport community?
Any student living within our school boundary that attends a community or a non-public school and elects to be transported, yes.
So the standard that we have for our Akron Public School students, the 2-mile K through 8,
Yes.
2 or more, is that the same standard we use for non-public schools?
Yes. Any standard that we put in, and I'll give you an example, if you would lower the standard, say, to 1.5 miles for our students that attend our student schools, we have to lower the standard to non-public and charters equal to. You must provide equal service.
Okay.
The next one is the board authorizes the superintendent to determine that it is impractical to transport. This is the payment in lieu that you see us bring the resolution in July, and then the subsequent listings that you see of the students that have been determined to be impractical to transport for one of 6 reasons. So there were just some modifications. And the one part which we always have done is and amount established by the state law and approved by the board. And so that's why the resolution always comes. The state standard for payment to a parent is set by the state in May, and then we approve each student in practical depending on their individual item. In this particular section, the sentence is now, however, the governing authority may not relinquish the transportation responsibility before the end of the school year and shall submit such notice. This is a change that did occur. Once you start a transportation route for a school, when they begin, say, in August, you cannot go in January and tell them that you are going to stop. You can notify them for the next school year, but you cannot stop in the middle of the school year. Now, the next sections, we had previously, these two sections have always been checked prior to this. What is the change is the green area. Bus routes shall be established so that the authorized bus stops is available within a reasonable walking distance, but not more than half a mile for students in grades pre-K through 8. The board shall approve bus stops and a time schedule annually, no more than 30 days prior to and no more than 30 days after the start of the school year. Most public school districts had felt that this was the start of its public school year. That is not the case anymore with this statute. It is each school. So as an example, if we had a charter school start August 1st, like our I Promise school used to, then you must have this all done at least 30 days, so it's beginning in July. It could go slightly later, but that's why the timing of this gets a little bit tightened up now with this change. The superintendent is authorized to make any necessary changes to the approved stops and routes, which could occur because you will have students that will certainly change schools, enroll in a school, leave a school, and we need to adjust those routes accordingly. And each student will be assigned to a specific school bus stop, except in unusual circumstances and approved by the superintendent. The district is not required to allow alternative stops based on shared parenting, daycare, or child care convenience. And that has been our standard here, but they have now codified it. And the rest was a strikeout. The bus times and schedule annually, no more than 10 days. They've changed that to the above statute. The strikeout for here, you could check that students may be permitted to eat or drink on the bus. We did not check this, and we do not want this to be checked for the safety of the students. This is due to a number of reasons. One's are choking hazards. As you travel, you wouldn't want a child to choke. And there's also the allergy issue. Something may be given to a student that is not appropriate due to a medical condition, such as, I'm going to say, a Snickers bar that has peanuts in it and somebody is allergic to peanuts. When that has occurred, you have to immediately pull aside the road and call 911. And we just tell our bus drivers that you do not eat on buses. We've had that standard for a long time. The next one is the addition of school buses and alternative vehicles now that that option is available. And the next one now gets into the board authorizes the use of an alternative vehicle, such as a van designated to carry 9 passengers or less, and to transport eligible students to and from a chartered non-public community school. And we do that. We have a number of locations in which some of our APS students are transported due to assignment by the SPED department to a specific school that is outside of our district, such as LEAP, and I'm trying to think of the other ones that are located in Portage and Northern Summit County. Yes, add alternatives. Thank you, Mr. Alexander. Yes, sir.
Will this?
This policy strictly covers our employees and our students here, okay? So that's another reason why we also had the 9 vehicles, because it also did your contracts for your van support through Buckeye and Templeton at this time. This board policy actually is general transportation. And it did say above that they contracted services, so therefore it would include your transportation by van companies such as Buckeye and Templeton. And these, most of these additions and changes were available at the time that we were negotiating the contract, and many of these are already in their current contract.
I'm asking because as we review the independent contractors policy, it would seem that this would conflict because now we're directing work. So I don't, and you don't have to answer that now, but when we look at the independent contractors policy that we're looking at, that if state law allows for one thing, and we're limiting that, and I'm assuming we have good reasons, but I just want to make sure we're consistent with both policies.
And then we still have, the drafting notice was just struck out because that gave you an explanation of the change from 9 to 12. Under C, the driver has a valid driver's license, is accustomed to driving the vehicle, it meets all statutory administrative requirements to drive the vehicle, including but not limited to pre-service and in-service training, pre-employment drug testing, criminal background checks, and participation in random drug testing. And this is the standard for all of our drivers, whether they are our drivers, whether they are our Peterman service drivers and our contracted companies. The district shall implement policies and/or programming for bus drivers that include professional development, annual performance reviews, and access to the wellness support programming as provided by DEW and ODPS. That is all in place now. The next drafting notice just didn't need to be left because that's back to alternative vehicles, but they did change the following. Drivers of alternative vehicles must conduct daily pre-trip inspections, and alternative vehicles must be inspected not less than 2 times a year. Excuse me, that standard has been in place for a long time.
And that's inspected by us?
Yes, that is. Or in this case, by the actual company that you do, excuse me for a minute, an actual company, so Peterman does their particular inspection, and so does Buckeye and Templeton. And those reports are available to us as well as to the Ohio Department of Highway Patrol that oversees our transportation. This is the statute for the McKinney-Vento homeless student, and the only change here is that the students meeting the federal definition of homeless will be transported via an approved method as appropriate. And some of our students qualify for buses, some of them qualify for orthopedic buses, and some of them qualify for van transport. And that's the end of that particular policy.
Any other questions on this policy? If not, we'll continue.
We'll go to the next one. This is 8600-04. Now, it was titled before bus driver certification. Now it is bus and alternative vehicle driver certification. So as you go through this, it is the fact that we now, every time you talk about a bus, you're adding the alternative vehicle drivers must obtain and hold proper certifications. And they already do have those. And those certifications are, when they are completed, are also part of the system at ODU that is available to the Transportation Department. And 21 years of age is the minimum age to operate a van, and 21 is the age that is in which we also have our school bus drivers do this particular type of meeting qualifications. The next was state pupil transportation regulations. It's just an add. It's always been state student. They updated that. And then do is to determine that such drivers meet the following qualifications at a minimum. So these are no changes here in the sections. These qualifications have been standard for a long time. And E is selected, not receive any violations that renders the bus driver uninsurable by the district's fleet insurance. And I will explain that. Once you get 6 points or more, our insurance carrier will not insure them to drive. Again, you had school bus, and now it is or van driver district certification. They put CDL in parentheses this time, and also then went ahead and put district certification. The next update is all drivers shall be enrolled in the retained applicant fingerprint database, which is correct. We all do that upon hire. And in this case, drivers and van drivers are recertified every 6 years. Regular employees, such as teachers, or every 5. DEW has not changed the bus drivers or van drivers to anything but 6. Satisfactory shall be defined as the standards in the administrative code, 3301-8323. So it's now specified. And then the next one is, and we highlighted it in blue as we have discussed this one. So as you read through it, any driver who has been convicted of or pleaded guilty to any disqualifying offense shall not be hired or shall be released from employment unless the person meets the rehabilitation standards. Some of these rehabilitation standards do not qualify to be rehabilitated. But we highlighted it in blue just to say it was there, but we did not select it. And now they've now struck out the word bus because you're basically talking about drivers. No driver will be permitted to drive a school bus or alternative vehicle transporting students unless the driver meets all other requirements contained in the rules adopted by DEW prescribing qualifications of drivers of school buses or alternative vehicles. In addition, no driver will be permitted to drive a school bus or alternative vehicle transporting a student unless, and then it's A and B. The check is the superintendent shall provide for the annual physical exams conforming to DEW standards to determine the driver's physical fitness for employment, and that is the T8. It must be performed. You can start taking a T8 physical in May, and you must have it completed and on file and pass that particular T8 prior to being able to continue to drive once the new school year is started. And then the last one is these drivers must have an annual physical. And they took out the word highway patrol at this point because it's not the highway patrol that determines the physical, and the driver is not employed by the school who drives a bus or vehicle owned must give satisfactory and sufficient bond. And that is the last update for this one.
Any questions on this policy? Okay, we'll continue.
Okay, so now we're at 8640. This is transportation for non-routine trips. As you will remember, we do have a resolution for non-routine trips. So now we have gone ahead and they have updated this policy to reflect not only school buses, but alternative vehicles. Again, the pre-trip inspections must be conducted no matter what vehicle you are driving.
Question, go ahead.
Yes, sir.
Yeah. Can you explain for the public the non-routine trips?
The non-routine trips are any trip a bus or van takes that is not taking a student to and from school on a daily basis. So this would be athletic trips, it could be field trips, it could be work to duty trips, because some of ours do internships during the day. So it's anything that is not directly from home to school and from home or from school to home. And then they did add in the next section, the school buses may include multi-function school activity buses, which meet all school construction standards but are not equipped with traffic control devices. So I want you to think of traveling in downtown Akron, and the SCAT buses, or what you will see what we call the RU buses. Those are not constructed in the same way. They do not have the stop arms when they pull to the side of the road. That's the construction they're talking about. Alternative vehicles may include passenger vehicles designated by the manufacturer for 9 passengers or less, not including the driver, and these multi-function school activity buses and alternative vehicles may only be used for point-to-point transportation and are prohibited from dropping off or picking up students at other locations such as their home. So this is strictly taking, to your point in your question, we're picking up a team of golfers at, say, North to go golf, and we're taking them back to North. And then we went through the various options that they listed there. These were the current standards that we operate under are the ones checked by X. The board shall provide the vehicles for all other trips, including co-curricular, athletic, and other extracurricular trips, but a mileage charge and personnel charge shall be assessed to cover the cost of the driver and the fuel. This charge is to be paid by the sponsoring organization from a designated fund. This is our standard procedure when we need to transport outside the normal school day for field trips. So as an example, some trips are actually sponsored by a community organization, and we bill them accordingly. A mileage per hour for the driver is currently $40 an hour, and the mileage is whatever the trip is on the IRS rate, which is currently 70 cents a mile. Yes, sir.
So if we have an organization, we have a school or an organization that do not have a fund, and we need to transport children, do we absorb that cost?
There are some supportive funding available in certain designated departments that will step up to provide that support.
So let me ask a different question. Do we ever deny kids transportation to extracurricular activities because they do not have a fund?
No, we do
Okay.
not. The next one checked is transportation may be limited to the availability of vehicles, drivers, and scheduling, and will not be available when needed for general purpose, school purposes. So we're taking you back and forth to school daily, but you need to do a field trip when we are taking students home. And in that case, we do have 12 current vendors that are certified with insurance, et cetera, that we can charter for and with. And then all field trips must be supervised by the members of the staff. All other district-sponsored trips shall be supervised by either staff members or adults from the sponsoring organization as approved by the superintendent. Anytime students are on the vehicle, at least one sponsor, chaperone, or staff member is expected to be in the vehicle, as well as to supervise students upon return to the district and while they are waiting for rides home. This has been our standard for many years, and it's very successful. The next one checked is all students are expected to ride the approved vehicle to and from the activity. A special request must be made to the staff member or sponsor by the parent in writing or in person to allow an exception. There is an exception that can be done, and we then can go into the next part of the next to it. So as an example, if I wanted my son to drive himself to an event, there is a Form 5515F2 that must be completed. We acknowledge that I am allowing Ryan to drive, and he is not to drive anybody else. He's driving for a reason. Sometimes he really just can already, he's a senior in high school, he has his own car, and he can drive to and from the event. But our real passion here is that they will go on the vehicles with the team and with the coaches that are supervising them. Yes, sir.
What if a kid is transported on the bus, let's say, to a football game, and they're at the game and their parents at the game and the parent wants to take them home? Can they go with the parent? Is that special circumstances? Or
They could only if the coach does the approval. Other than that, they're expected to be back on the bus.
okay, that doesn't require parent approval?
It requires the parent to go up to the coach and say, I'd like Ryan to go home with the parent. The coach is the only other one that can make that determination.
Now, what if a parent wants another parent to take
No,
the kid? Can they do that?
it's only the guardian of the child.
Guardian, okay, thank you.
And then the last one, the superintendent may enter into a contract with a public or private not-for-profit agency, group, or organization, with a municipal corporation or other political subdivision or agency of the state, or with an agency of the federal government to operate its buses to assist the agency, group, organization, or political subdivision in fulfillment of its legitimate activities and in times of emergency. The district may recover expenses from contracting entities not to exceed the cost of the operation and the insurance coverage. So this is one of those, as you are aware, we have helped out the city of Akron on emergencies occasionally to relocate people, as an example, for the fire that happened over off of Arlington, in which evacuations were happening. We were helping to provide those assistances. And that's the end of this policy.
Okay, any more questions on this policy? Pastor Harrison?
I have a couple questions on the one that we talked about. I think language really matters.
May I ask?
The board shall provide the vehicles for all other trips, including co-curricular, and the mileage should charge and personal charges to be assessed to cover the cost of the vehicle and fuel. Because we don't have an equity policy, I think we have to be very careful with language in every policy. And the way this reads could prohibit people from even attempting to get transportation. So if we've never denied anyone transportation based on their ability to pay or not, I think charging this to whomever is an administrative function. We have to find somewhere to put the cost of this vehicle, right? So I understand that, but I don't think it should be in policy because it's ambiguous as far as if I'm a teacher, if I'm a parent, and I say, well, I want to take the kids here, I want to take these students here, but we don't have the funds to cover the cost of the vehicle, of the fuel, of the mileage. So I don't see a purpose of having this in if we don't deny kids the ability to go places. Can you help me with that?
Sometimes all right, so it depends on when you're asking for us to transport. Yes, we can deny because we don't have any vehicles. That's why we have chartered bus services to our service providers that can help us do it. But we do everything possible to get our students. And the people that we're talking about charging, and I'll give an example. We've had Akron U sometimes say, hey, we would like kids to go to a basketball game, but we're to invoice Akron U for the transport. That's what this is about. It's not necessarily the teacher taking somebody to the apple orchard internally, because we do have priorities on
So
our
that's an
transport.
administrative function.
That is
So let's
correct.
put that in the administrative guideline and not have it in the policy. I don't like to put in a policy that we're charging if we're not charged. If that is not something that will prevent, someone, let's say, our homeless population. We're taking them to the art museum. Okay. We know where that funding will come from. We know who we will bill that to. Okay. But when you have something like that in a policy and it reads that we're going to charge X, Y, Z, that's still a barrier. That's a barrier to some of our students. That's a barrier to some of our programming that we do with our students in the schools. And so if we're going to find someone to charge that to, or we're going to eat it, or we're not going to charge, we don't need to have that we're charging in a policy.
There are occasional times, and I will say this to you, it's rare that it has done, but we've had public school districts and us cooperate to take students on college trips, and we bill half of that to the other district. So I'm just giving you some ways that we try to cover the cost.
Yeah, and I'm fine with that. I'm just saying let's not put we're charging in the policy. If we have an administrative function that we do, I'm sorry, did I cut you off? Go ahead.
Sorry to interrupt, Member Harrison. No, I just wanted to mention that language is in the current policy. I'm not, disagreeing or anything. I just wanted to remind everybody that will be a withdrawal from the current policy as well.
And we're going to have to review, and that's the purpose that we need to look at the entirety of the policy when we're changing language. And it's especially now that we don't have our anchor policy, which is the equity policy, to make sure all of our students are treated fair and that they get what they need. So now we have to look at every policy to make sure that that's anchored in every policy. And I'm just saying, when we make cost a factor, okay, we're a public school district, we operate on public dollars, and we serve all students. And I think our policies need to reflect that. So if, I don't want to get hung up on this. We can come back to this, but let's really take a look at that, because language matters.
I'm gonna be a little devil's advocate on that, and let's say that it's not in the policy, but then we want to charge them. But then I'm the other organization in Akron Public Schools said we need to charge you for this here. But you said it's not in your policy that you charge, so I can't charge you.
You put it in administrative guideline.
But administrative guidelines is just a procedure, process.
Absolutely.
Right, but the policy is what it is, and what you need to follow and what you need to do.
No.
Yes.
If we transport, if cost is not a factor of kids going to one place or another, then we don't need to have it in the policy that it is.
But what happens
Okay.
if we need to charge somebody and we can't, they say it's not in your policy? I'm the devil's advocate. I'm the agency that you're going to want to charge us to say we're going to do. So I'm going to say, you don't have that in your policy. It doesn't say anywhere.
We don't have lunches outlined in our policy, what
don't
we
have
gonna
to
pay
be.
for. No, because we know what we charge for lunches,
Right,
okay?
That's part of it. That's a different, but when you have something in there, you got to have something in there saying if you don't, then you can't charge. And if we don't charge, and then who's going to pay for that? We just saying we're going to pay for everything?
Well, no, we just said that if the students, if the organization don't have money, that they don't fail, we don't not transport them, we transport them.
Yeah, but not if it's Akron. Just saying we use Akron U because Akron U was one of the examples, and Akron U says, well, we don't have to charge you. You got to do it on your dime, So we can't charge Akron U when we need to charge them?
No, I'm not saying we can't charge them.
Well, if it's not in the policy, I'm saying, I'm just being devil's advocate, and I'm saying if you don't have it in your policy, and I'm Akron U, and you say you're going to charge me, and I'm going to say it's not in your policy to charge, what does it say that you charge me? I'm not going to pay you.
Well, you're an administrative guidelines specialist. You put it in administrative guidelines.
That's what I'm trying to tell you. Administrative guidelines is something totally different. You have a policy is one thing, administrative guidelines is different. Administrative guidelines tells you exactly how to follow the policy. Okay?
Okay.
And the policy says what the policy actually is, and it tells you in depth what is in the policy. So the policy says we have to charge them. The administrative guidelines says you got to get form this, do this, and do this, and get it done. Those two different things. So administrative guidelines, a policy is not a policy. It's two different things.
So then let's put in the policy that we do not refuse to charge, we do not refuse to transport based on the ability to pay or inability to pay.
One other thing I would like to bring to Mr. Alexander's comments. Certain grants are written for support various items. Part of those grants include the fact that they've supported in their request for funding for transportation.
Right.
So therefore, those guidelines are based on the policy that we can, and that's how it is built into the grant. So when you then work on the grant and you work with the treasurer's office, you have to show how you're using the grant correctly as to how it was awarded, including the transportation.
Right, administrative functions. Okay, and so when the grant says administrative functions, we don't list everything that comes under administrative functions. We don't list every paper clip, every piece of paper. We don't list all of that. We categorize that under one category. Okay, and yes, ma'am.
Member Harrison, I'm trying to make sure this is accurate at this time in this discussion, but there are times that our students are charged. I think about our CCAA programming. We had students come here from North asking us to pay because it wasn't in our budget to pay for them to go. So we do have a limited budget, and we do identify which activities they're going to participate in. And so there may be a time that the boosters will raise money so that kids can go certain places and they pay, you know. So there are times that I'm saying we charge the students,
Right,
the
but
families.
we're talking about plane tickets there. They came, they
It
wanted
could be
to go.
transportation, like a bus to Columbus.
I understand that, but I'm saying if we are allowing kids, students, to participate, if we want participation, cost should not be a reason for children, students, not to participate. And so what we're talking about transportation, we're talking about mileage, we're talking about a driver. So I just want to stay germane to this. I understand the students that came down from North, and I understand there was a lot of money that the district incurred that we were not expecting to incur. But now we're talking about a policy. Okay, and we're talking about transportation, we're talking about mileage, and we're specifically talking about the cost of the driver and mileage. So I want to just keep it narrow there. And we can come back to this, but I'm never going to look at where a public school district, we get public funding, okay? And we're a district of the haves and the have-nots, okay? And we want to make sure everyone is taken care of and everyone has the same opportunities. And if pay is one, then we as a district need to mitigate that. But we can't charge because those who have it to pay can pay. And if we're saying we're not denying transportation to anybody based on costs, then we shouldn't have it in the policy.
May I make a suggestion? If you look at that sentence, and it says, "The board shall provide the vehicles for all other trips, including co-curricular, athletic, and other extracurricular trips." But a mileage charge and personnel charge, instead of the word shall, may be assessed to cover the cost of the driver and the fuel.
Too ambiguous. We can
Thank
come
you.
back to this another time.
Thank you.
Because I will continue to disagree with that, because
Okay.
you gotta have some way to pay, and we're talking about we don't have money, but then we're talking about paying for everything. But we on one hand we don't have money, on the other hand we're paying for everything. We can't handle both. We don't have the finances.
Because we pay for what we want and we beg for what we need.
Not always, no. And what we're saying, basically, what we're saying is that we want to make sure all of our students get an opportunity to do that, and it means that we have to charge Akron U because they have the finances, or some other organization, so that our kids can go. Then we charge them. You know, if not, then they don't go. So now we're saying, do our kids go or they don't go? They don't go because there's the money available. But if this corporation over here, or if this university over here, or if this organization over here wants to pay to help our kids go, then yes, we can charge them that because they have the money. But if we don't, some of our kids don't go because we may not be able to afford it. Our budget is already tight, and it's getting tighter, so those kids won't go. So we have to find other ways, such as this here, to charge people to make sure our kids have an opportunity to go on these trips and have these experiences they really need. So, I mean, if you guys want to come back and address this here, you can, but I think that you need to have that in there, because if not, and I would, if it ever happens, I'll be one of the first ones here to say it did happen, and I told you it shouldn't happen, because we won't be allowing our kids to go. So we'll move on.
Our last one is 8650, transportation by alternative vehicles. And this is the one that goes through when this transportation of students by school bus is not practical, then the Board of Education may provide transportation to students via board-owned vehicles and/or operated or contracted alternative vehicles. And this is the standard that has been in place. It is reflecting the same type of information that has been in the earlier policies. Passenger vehicles meet the capacity restrictions. The number of students in vehicles does not exceed 9, which we have discussed previously. This one doesn't have a lot of changes. Again, the driver's age is 21, which is selected there at the top of the second page. And that is the end of that particular policy.
Okay, any questions on this policy?
Brother Chair, this is another policy that we need to make sure is consistent with the IOC policy, the independent contractors.
And it currently is.
Well, no, we're reviewing that.
Well, I just meant it
Yeah,
meets the
so, yeah,
current
we're
vehicles that are in their contract. Thank you. Thank you.
Okay, any other questions? No other questions. Okay, I will look at our legal person. Do we have anything else we need to discuss or go over? If not, then we'll move on.
Those were the policies that we had on the agenda for this evening.
Okay. All right, if there's any other questions or comments or concerns, if there are not, we will adjourn this meeting at 6:48. Thank you for everyone who has participated and watched. Have a good evening.